today, this panel will help us demystify the Supreme Court advisory opinion on division of revenue and its implication on the national budget process. Over to you, Professor Jill. We'll start off with you giving us your insights. And because of what this Constitution of Kenya is touted for as an instrument of transformation and reconstruction, with explicit mandatories to key stakeholders on how to effect the transformative project, it has introduced fundamental changes in the governance structures and the processes in the country. In your opinion, what did the Constitution envision with regards to the division of revenue between the national government and the county government?
Counties get most of their money from the national government, partly because only the national government can raise certain taxes like most taxes in fact, such as income tax and customs duties and VAT and so on. It's not hard to imagine why. If each county could raise income tax, you can imagine how wealthy Nairobi would be and how poor many others would be. This is actually a very common arrangement for in a system of more than one level of government, that the lower levels get a lot of their money from the national government. In South Africa, for example, at least in 2018, I think the figure was that the provinces raised only 2.3% of their own income. So having set that up as the arrangement, then there has to be a process for how you divide the money. So first of all, the money has to be raised by the national government. You have to decide how much is going to be distributed between the nationals and the county sectors, and then how much each county should get. Then the governments, each government, national government and county governments, have to budget about how they're going to spend the money they have. And every stage needs approval of the relevant elected body, the National Assembly and sometimes the Senate at the national level and county assemblies. And every stage needs people's participation. The Constitution sets the framework for this exercise. And principally, it has sort of three elements to it. There's the timing of the process. There's the question of who decides at different stages, and the question of how they decide, the basis for their decisions. The Constitution, on the timing issue, the Constitution tries to ensure that there are no hold-ups. It also deals with the risk that for some reasons things are actually delayed. So the Constitution says at least 2 months before the end of the financial year, that is by the end of April, there must be laid before Parliament a thing called the Division of Revenue Bill, which is about dividing the money between the national and the counties generally, the County Allocation of Revenue Bill, which becomes an act dividing the money between the counties. And you will have seen in yesterday's newspaper that process is going on in the Senate at the moment, and there are some disagreements. And something else that has to be laid before Parliament are the annual estimates for the national government, what they anticipate they're going to be raising, how they're going to raise money and what they're going to be doing with it during the following year. Counties will be doing the same. That is called, and then there has to be a bill which is drawn up for the National Assembly to pass so that the money can actually be spent. And that is the order, incidentally, in which the Constitution deals with these matters. So then the question is, who has to make the decisions at these various stages? And there's an interesting design, I think, in the Constitution, that there are 4 elements in this process. There is some expertise built in. There is a very great role for elected representatives. There is the role of the National Treasury, and there is the role for the people. So the expertise on revenue allocation. And these people are nominated by the President or the National Assembly or the Senate, which makes them sound rather political. But in order to be appointed, the Constitution says they must have extensive professional experience in finance and economics. So here you've got people who are supposed to be sensitive to the interests of the various parties, but also to have strong expertise. And that body is to make recommendations whenever issues of division of revenue come up for decision. Then there are the elected bodies. And this, of course, is where these cases have particularly arisen. The role of the National Assembly and the Senate. And Dudley will be dealing with the intricacies of the legal arguments on that. And there are roles set out for the Senate and the National Assembly. And then there's the people, very important. At various stages, the people must have an input, such as, first of all, when the Commission on Revenue Allocation is considering its formula for distributing the equalization fund to assist counties with marginalized communities. I myself have been to one of those meetings. Every time Parliament passes a law, whether it's a division of revenue legislation or something completely different, the Constitution says they're supposed to have public participation. And indeed, some legislation has been challenged precisely because it did not have adequate public participation. We shouldn't forget that actually the Constitution is not the whole of the law on this subject. There is the Public Finance Management Act, which has more provisions about timing and public participation, and including things like the medium-term expenditure consultations. And it has a more elaborate and extended annual timetable for the whole process of budgeting and so on. Now, I think for our purposes, perhaps, as I say, Dudley will deal with the intricacies of who has the power. It's important to bear in mind the how these decisions are supposed to be made. And the values of the Constitution become very important. Even those values which are set out in general terms in Article 10 of the Constitution, like the protection of the marginalized, public participation, social justice, equity, all these are found in Article 10. But then also, in order to understand the background, we should look at Article 174, which sets out the purposes of devolution itself. The importance of using the recognition of diversity within the country as a way of strengthening national unity. And the fact that devolution is supposed to give to communities the control of their own affairs. And also that devolution is supposed to ensure to people easily available services. All this is in Article 174. And then you come to the more specific provisions about dividing the money. And even if you look at the language, the Constitution speaks about the equitable share that the counties are supposed to receive. If you like, the equitable share of the national government and the equitable share for the counties. And the important word being equitable, fair. Then the other expression which is so important is the equalization fund, which is not part of our discussion for today, but again it shows what are the functions of dividing money to try and achieve one of those major objectives of the Constitution, that is equality. So the aims specifically set out in the Constitution, Article 203, include things like efficiency. Money is supposed to be used efficiently, it's supposed to be distributed in a way that will encourage efficiency. It's also supposed to be sufficiently flexible to meet the different needs, as time goes on, changing needs. But also there's supposed to be predictability of resources. Counties, and indeed the national government, should be able to know with some reasonable degree of certainty how much money they're likely to be getting. And then there's supposed to be fairness, again, social justice, including affirmative action, that is, some preference and special consideration for areas and communities and so on that are disadvantaged. There should be encouragement of prudence on the part of those who spend money, and encouragement of commitment to raising money. It's not intended that counties should just sit back and wait for the national government to distribute money. They're also supposed to be encouraged to make the most of their own resources, even though their powers to raise taxes are rather limited. They also can raise money by offering services and charging reasonably for them. There's also the possibility of the national government having some influence over how counties use money by being able to give specific grants for particular purposes. They can give unconditional grants, which they would probably not do. They can give conditional grants. This money is for you to spend in a certain way. So this way they can give some influence. But that is supposed to be limited. The bulk of the money that is supposed to go to counties is to be left to the counties to make their own decisions of how they need to spend it in the light of the needs of their county. This is why there is a minimum of the 15% of national resources, the resources raised nationally that have to go to the counties as a group. Just mentioned was the need for a cooperative spirit. This involves a lot of different bodies, and there are obvious tensions set up in the Constitution. The Senate is set up to protect the interests of the counties. And of course, if they take that job seriously, it's going to lead to some sort of potential for disagreements. But it's not supposed to lead to complete deadlock. And the Constitution emphasizes frequently the need for cooperative relationship, particularly where devolution is concerned. If all these bodies are rigid and stick to their positions and pushing particular concerns and interests, then we will have deadlock. In fact, there was an earlier case from 2013 when some similar issues arose. That was a case in which Katiba Institute was also involved. And I just wanted to quote from the Supreme Court on that occasion. The Supreme Court emphasized in various ways the need for cooperation. The majority judges said no state agency should overlook the historical trajectory of the Constitution, which is clearly marked by transition from narrow platforms of idiosyncrasy or sheer might to a scheme of progressive, accountable, institutional interplay. Everybody should be operating in a cooperative way, recognizing the role of everybody else. And the then Chief Justice delivered a separate judgment in which he said, in the equitable distribution of resources owned by the people of Kenya, and he emphasized owned by the people of Kenya, the principles of checks and balances, mediation, dialogue, collaboration, consultation, and interdependence are not necessarily conflictual, granted that they are all invoked in the interests of the people of Kenya. That, I think, is really the message of the Constitution. Thank you very much.
Now, I think we will move to Wakili Kamodo. Given that background laid out by Professor, we note that the implementation of the devolved system of government is a cornerstone of the Constitution of Kenya, and it has brought a major policy shift on how resources are shared in the country. The Constitution has, like we have been told by a professor, laid out policies and guidelines on sharing of resources between the two levels of government. But despite this well-formulated guideline, there has been delays and standoffs on the amount to be allocated to county government. There is also concern on delays with disbursement to counties by the National Treasury. affecting service delivery substantially. What is your take, Wakili, on the current practice on division of revenue in the country?
The background set by Professor Guy is critical, because we need to understand just how critical democratizing the process of revenue allocation was in the design of the Constitution, because you cannot call a devolved system a strong system if the traditional methods by which we allocated revenue inform the new infrastructure. But unfortunately, what has happened over the years is that because in the design of the constitutional framework, the division of revenue framework in the Constitution, there were certain compromises and there were also certain defects, and I would say some sort of, maybe not contradictions, but some gaps. And those gaps have been used by institutions that have traditionally occupied the responsibility of allocating revenue to continue to exercise powers as if the constitutional framework did not change. And I'll give you a few. One is that one of the things that the Constitution did was to create the Commission of Revenue Allocation. And the intention of that, of the creation of that institution, was to ensure that the process of revenue allocation, one, is rule-based, is informed by technical expertise, but so that by the time the political players get into the picture, the critical issues, technical issues have been resolved. Now that institution, the CRA, was even given the powers of an independent institution, complete with security of tenure. And one would be asking, why would you create an institution of that nature, allocate it security of tenure, give it constitutional independence, and yet its role appears to be purely advisory, which is the interpretation that the actors in the process has given. If you look at the way the recommendations of the CRA are handled, particularly by the National Treasury, it is as if they have no role. There is no difference between them and any other actor, any other, the association of communicators, or, the association of bloggers. There's no difference between the recommendations that they give and any other institution, even though it's clear that from the spirit of the Constitution, this was supposed to be the preeminent institution that, in a sense, gives guidance. And that is why it even comprised the various political actors and even the PS Treasurer, who is the principal man in the national government for principal person for giving advice on financial issues, became a member. So, but the way the Constitution was done, the powers of the CRA were diluted in the process between bombers and the eventual draft continually. That then means that the advice is never taken into account. The other problem is the question of the design of the right to budget monies as between the national government and the county governments. The way the Constitution again is designed is that the national government under Article 221 is permitted, or appears to be permitted, to appropriate money and start budgeting on the 1st of July, whether or not, to appropriate by the 1st of July, whether or not the Division of Revenue Act has been passed. Now, that is because the provisions relating to the budgeting process in Article 221 by the national government and the provisions relating to the Division of Revenue process are not synchronized by the Constitution. It appears as if those two processes are independent, which means that the national government has traditionally, in the last so many years since 2010, has proceeded to appropriate, to prepare its budget, to appropriate even when there's no agreement on division of revenue. And the question that becomes obvious to anyone is, what is the national government appropriating if the allocation of revenue has not been done? And the assumption has always been that the person who should be compromised, prejudiced by the failure to arrive at the division of revenue, is the county government. And that is because if you read, I believe it's Article 218 or thereabout, it says that the county governments cannot budget, they cannot start their process of budgeting, and therefore they cannot appropriate before the passage of the DoR, which then means that therein you have unequal powers as between the national government, which is able to spend money whether or not DoR is passed, and the county governments, which must wait, which must be at the mercy of an agreement on the DoR. The natural consequence of that is that the national government can afford to wait and let the crisis of failure to agree on the DoR pass because they are not prejudiced. The county governments, unfortunately, if the DoR is not passed and they cannot get their funds, then it means that you then have a crisis of service delivery. People start complaining about governors not delivering, and therefore it causes tremendous prejudice to the county governments. What then means is that when the Senate and the National Assembly are negotiating on the respective allocations of revenue, the Senate must always be aware that if it does not agree, the people who will serve our county governments, not the national government. And that forces sometimes the Senate to accept lower allocations, because if they don't, the crisis is then owned purely by county governments. So what has happened then is that the National Assembly has used that privilege to push the Senate to accept whatever it is that is on table. There's a third problem also. The national government is allowed to access, even if they don't have an Appropriation Act passed by the beginning of the financial year, they are allowed to appropriate up to 50% of their budget. So even if at the National Assembly there's a delay on the allocations on the Appropriation Act, the national government can even then still be able to appropriate 50% of its budget. The county governments don't have that opportunity because they cannot even prepare the Appropriation Bill, because there has not been a Division of Revenue Act passed and there has not been a County Allocation of Revenue Act passed. These sort of the challenges in the design of the Constitution have then been exploited by some of the actors to prejudice county governments. And the problem has been that the actors have then forgot or failed to recognize the spirit of the Constitution and gone to its letter and implemented it and interpreted it in its worst possible manner. Now, the problems, those problems of design, the challenges of design, are very much a feature of the process by which we came to write our Constitution. And in fact, in the matter that was Professor Jill mentioned, the 2013 issue on the division of revenue, Dr. Willie Mutunga actually raised the issue, and he said, look, when a constitution is being written, it goes through a political process. And so there are going to be numerous compromises that sometimes go against the spirit of the Constitution. And the role of the Supreme Court is to ensure that it cleans those inconsistencies so that all the provisions of the Constitution are consistent with its spirit. You can imagine talking about one of the design problems that was there in the Constitution. If you read the Constitution literally, without looking at its spirit, the Senate was not even supposed to be involved in the discussion of the division of revenue. In fact, the National Assembly in the Supreme Court decision maintains that position, that constitutionally the Senate has no role in the division of revenue. That is not a bill affecting counties. You can imagine just how strange that would sound, that the most important decision, which is about how much money goes to county governments, the Constitution was interpreted until the 2013 case to mean that the Senate has no role in the process of determining the division of revenue to county governments. So these design issues, these design challenges have then informed the current process, where inevitably a proposal is made by the CRA. That proposal is ignored when the National Treasury is preparing the Division of Revenue Act, the Division of Revenue Bill. It ignores the views of the Senate. The National Assembly, which considers itself the protector of the national government. And there are many reasons for that. One is that if you look at some of the challenges that we have in that process, it is that the National Assembly has a perverse incentive to ensure that county governments, the national government, gets more money than county governments. Why is that? Don't forget that after the case that was done on NCDF, on the previous CDF, The court then, and I believe Katiba Institute was with us when I was in CIC on that case. The court said that the CDF allocation will be based on the allocations of money to the national government, the proportion of the allocation of money to the national government. That means the more money the national government gets, the more allocation is available for the CDF. So there's an incentive there to ensure that the national government is allocated more and more money, because then the CDF allocation, which is controlled by members of parliament, informally and formally, is then higher. That means there are several problems. That's why there are several problems that infect this process, that makes it impossible for county governments to get their rightful share. And the issue then that was taken to the Supreme Court is to try and resolve some of those questions to ensure that the processes are consistent with the spirit of the Constitution. The matter does not end there. Even after the monies are allocated to county governments, the body responsible for actual release of the allocations to county governments is the National Treasury. Now, when the PFM was passed, it provided that those funds would be passed initially quarterly, and then it was agreed that it would be monthly. The reality is that over the years, the National Treasury has not been sending monies to county governments on time. In fact, initially, if you read the PFM Act, it provides that county governments will agree in the context of the IBEC, that's Intergovernmental Budget Economic Council, on how much money they need at any one time. And that disbursement schedule, once it is passed by the Senate, then the National Treasury will just be releasing the money. The truth of the matter is that over the years, these monies are not released on time. So that, like last year, you can check, because in fact, the National Treasury quoted that in their documents in the Supreme Court, about 35% of the allocation to county governments was released in June, just before the end of the financial year. Now, remember that if you look at the way county governments budget, only about 30% of the money goes into development. 70%, 65% goes into recurrent expenditure, the purchase of drugs and all that. Which means that by the end of the financial year last year, there was no money allocated for development to county governments. This is in clear contravention of the Public Finance Management Act. So that is one of the areas in which the National Treasury has actually been misusing its powers, the power of the past, in failing to release money on time. So that the problem is not just the challenges in allocation, but also the challenges in terms of release of the money. The one final thing I want to say is that for us to understand just how bad the situation has evolved over the years, if you look at the numbers between 2013 and this year, and you compare the amounts allocated to county governments in those years as a proportion of the revenue that the country collects, you will find that those numbers have been going down from an initial about 23% to last year about 17%. So effectively, the allocations to county governments have continued to reduce because of the misuse of the powers that I talked to before. This year, for us to know how bad it was, the allocation to county governments were actually below inflation. So that effectively the amount, the services that counties were able to deliver last year, they could not deliver them this year because the cost of those services went higher and the effective allocations went down. So the problem has been that over the years, the misuse of the parties' constitutional powers, the refusal to have effective consultation has been very, very prejudicial to county governments. And county governments obviously have no recourse. Hence the Supreme Court case.
Over to you, Mr. Kegoro. I think Wakili has very ably demonstrated how the rule-based and technical expertise intention of the Constitution to set ground for division of revenue has been hijacked. While we should not be concerned when the process has become heavily political, we should worry when and if it becomes exclusively political. While the division of revenue is by design a political process, there's clearly urgent need for concerted effort to avert the stalemate that has become the permanent feature of division of revenue process. Okay, in your opinion, Wakili, how are the political interests impacting division of revenue, and how can this be managed moving forward?
After the Senate and the Assembly failed to agree on the division of revenue last year, the matter was submitted to mediation. The Senate appointed its chair of finance, Mahmoud Mohammed, to its mediation committee. It also had the majority whip, Susan Kihika, Makueni Senator, that's Mutola Kilonzo, Sakaja, and Ledama. Now, these were selected on an approach of subject matter expertise to be the representatives of the Senate in the mediation process. The National Assembly presented the following as its representatives in the mediation process. The majority leader, that is Adan Duale, the minority leader, Badi, then the deputy majority leader, Susan Barire, and the budget committee, the budget committee chair, that is Ichungwa, and a member of that committee, Makali Mulu. So the Senate had a sort of an expert subject matter approach to the mediation process. The National Assembly had a fairly different approach. It presented the two alpha males in the House, that is Duale and Badi, as part of the mediation process. So basically, the process, the Assembly maximized on its power at that stage, making it very, very difficult that informal consultations that would be tie-breaking in nature could have been. I mean, an argument can be made that if you present Duale the best of the best in the first instance, then it means it's not available for consultation in terms of informal consultation that might end up being breaking the tie or breaking the stalemate. So these differing approaches to the breakdown in the negotiation of the bill is informative of the approaches the two houses have had. The Senate has at every time tried to demonstrate reasonableness, an approach that lets us talk together, and it is an approach that is based on a certain meekness that the House has accepted in terms of its place in financial matters. On the other hand, the Assembly has proceeded as evidenced by this occasion on a basis of we are the strong one here. We will not. We are not available to mediate. We are not available to negotiate. It is either you take it or you leave it. Now, when the mediation process failed, the Assembly then passed its own bill and presented it to the President, who assented to it. Now, that is another level of failure, and it speaks to the political questions that you've asked about. Was it available? Was the President aware of the path that the bill had passed for it to be presented to him for assent? Yes, he was. He would have been advised that this bill was passed unilaterally by only one house when two houses needed to pass it. Was the President advised about the 2013 mediation process? Yes, he was, and should have been advised. Was the President therefore reasonably aware that when he was assenting to this bill, it had the difficulties, or it was likely to lead to the difficulties that have ended up in court yet again? Yes, he was. Now, therein lies the second layer of political problems. the political problems start in the assembly, but they do not end there. They also they proceed to the level of the presidency. The totality of the situation regarding the relationships around budgeting is that the presidency, the assembly, and the treasury have played hardball. They have played a game of brinkmanship, maximizing their power at every turn, and presenting the Senate with a situation where they are told you take it or you leave it. So I think in terms of the budget making process, has created a dichotomy, whether or not intended or not intended, between the three strong institutions, which is the National Assembly, the Treasury, and the Presidency on the one side, and the three weak institutions, that is the Senate, the Judiciary, and the Commission on Revenue Allocation. So you've got you have what are between 2013 when we had the advisory opinion, and then now in 2019 when we've had another one, we have come into a situation where we have consolidated an ideological commitment to a certain way of doing budget. That ideological commitment is ingrained in the outlook of the three ascendant institutions, that's the Treasury, the Presidency, and the Assembly on the one side, and the outlook of the other three institutions, which is the Judiciary, the Senate, and the Commission on Revenue Allocation. And we need to also, I mean, if you look more closely into the place of the Judiciary, you've got to look into what happened in the Supreme Court. You had a minority opinion, that is Njokindungu. Now, Njokindungu is traditionally based going down to the 2017 presidential election petition, for example. She dissented on that occasion with Ojwang, and I think there is enough evidence now to ascribe to her an outlook, a centrist outlook that is very similar to the one that has been that is shared by the three ascendant institutions. So countries decide for themselves what issues are what issues can be the subject of reasonable mediation or reasonable conversation where you resolve amicably and move the society forward, and what issues are the basis of division between segments of their society. So, for example, for the longest time, the Americans decided that bipartisan approach has broken down in recent years, but the Americans decided in the early years that foreign policy was going to be an issue that doesn't break them down their representative organization entities, that is Congress, along party lines, and that was in place for very many years, but that has broken down in more recent years. Now we've decided in this country, it seems, or very early on into the new constitution, that budget making is going to be characterized by two dominant outlooks: an outlook that is shared by the presidency, the treasury, and the assembly, which is to the effect that this power is going to be concentrated in those three institutions to the exclusion of any other power, and then sets up the court, the Senate, and the Commission on Revenue Allocation, and a very, very thankless and extremely difficult task of trying each time to undo what those three are committed to doing. So it is a game of brinkmanship. It is very deliberate, and it is based on a view that we don't have to talk to anybody else, because if we work together, we are too powerful for anybody to breach. You've got to add to that what Kamodo said in his presentation, the idea that the National Assembly has an embedded self-interest in the positions that it takes because of the functioning of the national government CDF from after 2015. The National Assembly gets 2.5% of the ordinary revenues that are voted to the national government in the budget process. So that's a significant amount of money, that it amounts to about 40 billion in the last budget. And if you put in its institutional budget, so about 40 billion NGCDF, and its institutional budget of about 40 billion, that is more than 80 billion that Assembly gets to control. If, for example, you contrast that with about 16 billion that the judiciary controls, it shows you the vastly different positions that the two institutions find themselves placed in terms of the budget making process. Thank you very much.
And now that we actually see that the presidency and the National Assembly, and therefore Treasury also, has an interest they try to secure in this process, I'm keen to hear from Mr. Ochiel how the Supreme Court advisory is going to help us move beyond the political interests that are at play. It is evident that the Supreme Court advisory has caused some confusion, which might lead to future court cases, and therefore is highly likely not to help this quagmire we find ourselves in. Among the observations out is the opinion that the opinion given by the Supreme Court might lead to a protracted process rather than provide the much needed solution for which the advisory was sought. Wakili Ochiel, I would like to hear your opinion on this.
During the financial year 2019, there was a long dispute between the National Assembly and the Senate concerning the Division of Revenue Bill. That is the bill that divides revenue raised by the national government between the national government and the county government. By law, the bill must be passed into law by the end of the financial year, that's the 30th of June, so that at the start of the new financial year in July, on the 1st of July, both governments have money to exercise their powers and perform their functions with. That bill would not be passed until September 2019, 3 months into the new financial year. And the meaning of that is simply that the county governments did not have money to perform their functions. And under the Constitution, one of the objectives of having county governments is to bring services closer to the people, so that you don't have to come all the way to Nairobi to access services which the county government can give to you in Kwale or Migori or Turkana. And so the matter went to the Supreme Court for its advisory opinion, and 4 questions were raised. The first question was whether the recommendations of CRA are binding on Parliament. The second was what should happen when Parliament fails to agree on the content of the Division of Revenue Bill. The other question was whether there should be timelines within which National Treasury must release the shares of county governments. And the other question was whether the National Assembly can appropriate for the national government before there is the Division of Revenue Act. On the first question, the Supreme Court held that the recommendations of the CRA are not binding. Parliament does not have to go by it. However, those recommendations are weighty, and Parliament must consider taking into account the criteria at Article 203 of the Constitution. The criteria in that article include some of the following matters. One, national interests, which are cross-cutting issues and not the interest of the national government. Those are issues, for example, like the coronavirus pandemic now. It's a cross-cutting issue. It affects the national government and it affects all the 47 county governments. The other is the ability of county governments to perform their functions, the needs of the national government, which in my view would refer to the functions allocated to the national government. The other issue is a predictability, reliability of revenue allocations to the county government. So as Council Mr. Waiganja stated before, that would require Parliament to take into consideration the fact that it can't allocate lower, because when you allocate revenue below the levels in the previous year, it means that the services which are offered in the previous year cannot be offered in the next year. At the same time, county governments must be able to at least predict the kind of revenues they're going to get. There can't be a drastic change unless there's an emergency or some other unforeseen circumstance. On the other issue regarding impasse between the two houses of Parliament, the Supreme Court stated that if the two houses cannot agree on the division of revenue bill, then the National Assembly should allow county governments to access at least 50% of the equitable revenue from the previous year. And if that 50% is more than the amount allocated to them in the division of revenue bill, then they should access at least 15% of the revenue raised by the national government. The other thing that the Supreme Court stated is that where Parliament fails to agree beyond two circles of mediation, they make one attempt at mediation, they don't agree. They make another attempt at mediation, they still don't agree. Then any person can go to the High Court and petition for the Chief Justice to advise the President to dissolve Parliament. If that petition is allowed, then the Chief Justice will advise Parliament, would advise the President to dissolve Parliament. There's no specific constitutional provision for that outcome, but the Supreme Court looked at the 5th schedule of the Constitution. That was the implementation schedule when the Constitution was first passed. The Constitution provided a period of up to 5 years for Parliament to pass all the legislation necessary to implement the Constitution. So the Supreme Court imported that principle, the principle of timely enactment of legislation necessary to the question of the division of revenue. Because this is also a time-bound legislation. It must be passed within time because it is the bill or the legislation which provides revenue that enables the county government to exercise their powers and perform their functions. So the Supreme Court imports that provision of timeliness. On the question of inordinate delay in the transfer of funds to county governments, the governors had complained that they get their allocations too late in the day. First, they allocated too little money, then the money comes when it's too late to spend it. It comes sometimes at the very end of the financial year, so they can do nothing with it, and the money goes back to the consolidated fund. While the Supreme Court did not set any specific timelines, it stated that any delay in the in the transfer of revenue to the county governments must be explained at a forum convened by the national government. So the Treasury has no discretion to delay the transfer of funds. It must tell the county governments why there's a delay in the transfer of the funds. I think the Supreme Court's approach to the issue is understandable because revenue includes accruals. It does not only refer to the money which is already there. It refers also to the money proposed to be raised, for example, through debt and borrowing. So the Supreme Court's approach to the issue of delay in refusing to set a specific timelines but requiring delays to be explained is understandable from that perspective. The last issue, and as I move to conclude, is on whether the National Assembly can appropriate for the national government before the Division of Revenue bill is passed. Last year, while the matter was still pending in court and before the Division of Revenue Act had been passed, the National Assembly moved to appropriate for the national government. And the question is, before the meal is served and brought to the table in the bowl, how can someone get their own share from what has not been brought to the table? That is what the National Assembly purported to do. So it relied on Article 221, which applies where the Division of Revenue Act has been passed, but there is a dispute at the national government as to the allocation within the national government level. It cannot be used where the Division of Revenue Act has not been passed because you cannot allocate what has not been, you cannot appropriate what has not been divided to you. First, there must be a vertical division between the national government and the county government. Then the national government can allocate within itself from the share allocated to it, while the county governments can also make their own budgets from the share which is known. So the Supreme Court held that the National Assembly cannot appropriate for the national government before the Division of Revenue Act is passed. Allowing that to happen has the effect of allowing the national government to continue with its own functions while holding uncertain the shares of the county governments. And the Supreme Court also directed Parliament to enact legislation to give effect to the findings of the Supreme Court. And just to conclude, the advice of the Supreme Court, though it sounds like discretionary, sounds like advice, is binding. It's binding on the national government, it's binding on Parliament, and it's binding on the county governments. It's not mere advice, though it's called advisory opinion. It's also not a mere opinion. I think I'll leave it there for now.
We'll move over to Mr. Gishana because South Africa and Kenya are countries that can be compared in terms of their legal provision. I believe we too can compare how the two systems have so far been implemented and how they have functioned at this point, specifically on matters of division of revenue, because PFM, the PFM measures are largely copied from the South Africa approach and principles to PFM. Mr. Gishana, I believe there are lessons that Kenya can learn from South Africa's experience, both what to do and what not to do. And experience you bring out should be of great importance if placed in the context of the broader background and debate on dynamics and the pros and cons of politics of decentralization. Please take us through the practice and division of revenue in South Africa and what lessons Kenya can learn from their experience of South Africa.
As Valerie mentioned, there is a great deal of similarity between the intergovernmental fiscal system in Kenya and that of South Africa. And that is predominantly because we borrowed very heavily from the South African Constitution, and we also borrowed very heavily from the financial laws that regulate the division of revenue and the sharing of revenue among the levels of government. So one of the things which I think we ought to understand, even as we're trying to get the lessons from South Africa, is that in as much as there is a level of similarity mainly on principle, the principles that have been borrowed from the South African Constitution and the principles that have been borrowed that have informed our Public Financial Management Act, in terms of the multi-level government structure or the decentralization structure, there's differences, and there are also different dynamics in terms from a political standpoint that influence the division of revenue in South Africa. So to begin with, South Africa, compared to Kenya, South Africa has 3 levels, spheres of government: the national, the provincial, and the local government. So we have 9 provinces and we have 257 municipalities. So you realize that each of them, similar to Kenya, are distinct, but they're also interrelated. And each of them are entitled to a share of the equitable revenue which is raised nationally. However, what is unique in the South African case is that despite having 3 spheres of government, the revenue sharing process mainly focuses a lot on the national government and the 9 provincial governments, with a little bit of input from municipalities through what the South African Constitution refers to as organized local government, which is basically an association of local government institutions, which is more or less comparable to the Council of Governors in Kenya. So at the national level, there are 2 houses of parliament, similar to Kenya, the National Assembly, and in South Africa, the contemporary for the Senate is the National Council of Provinces, which is otherwise referred to as the NCOP. So, and provinces have legislatures, municipalities have municipal councils which deal with individual budgeting processes. But then another important feature also the South African system, which we have to point out before we start, is that the electoral system plays a part as well in how the politics of revenue division actually play out. You realize, unlike Kenya, where we have a first past the post electoral system, in South Africa, we have a proportional representation electoral system where representatives of municipalities, representatives of provinces, and the National Assembly are elected by way of party lists. So what that means is that there is a lot of prominence that is given to parties, political parties, and that there's a lot of allegiance that is given to political parties. For instance, since independence, the African National Congress has been the party that has been in leadership. And your affiliation as a politician to the African National Congress or getting a ticket from the African National Congress is as good as knowing that you've actually been duly elected. So you realize that the party controls a huge number of members, both at the National Assembly, at the National Council of Provinces, and at the municipal level. So in terms of the legal framework that regulates the revenue division in South Africa, we have the constitutions, and similar to Kenya, we have a Public Financial Management Act and a couple of other acts. And of similarity again to Kenya is the Annual Division of Revenue Act, which is required to be enacted annually. Now, when it comes to the players in the division of revenue, similar to Kenya, we have the involvement of the national executive, the involvement of both houses of parliament, and the involvement of an independent commission, which is similar to the Commission on Revenue Allocation in Kenya, CRA, which is called the Financial and Fiscal Commission, FFC. So provinces are also, provincial legislatures are also allowed to take part in the division of revenue. And again, as I mentioned, local governments through organized local government, a body called the South African Local Government Association, otherwise referred to as SALGA. Now, worth noting is that the National Council of Provinces, which is the equivalent of the Senate in Kenya, is made up of delegations from provinces. These are not people who are actually elected to the National Council of Provinces, but they are chosen from elected representatives at the provincial level. So each of the 9 provinces sends 10 people to the National Council of Provinces. And the head of this delegation is the provincial premier, which is an equivalent of the governor. others are members of the provincial legislature. So you realize that the National Council of Provinces doesn't have directly elected representatives. It has representatives from the provincial legislatures, and the governor or the equivalent of the governor heads that particular delegation in the National Council of Provinces. What this does is that the governor is able to take part, or the premier is able to take part in the deliberations of the National Council of Provinces. And there are also other intergovernmental forums, for example, Budget Council, which is, so we have two, because of the three levels of government, we have two intergovernmental forums that deal with financial matters. We have a Budget Council, which is just a consultation between provincial governments and the national government. And then we have a budget forum, which includes all the three spheres of government, the national government, the provincial governments, and organized local government, that is representatives of local governments. So this budget forum, which is an equivalent of IBEC, is the one where consultations regarding the division of revenue takes place before the division of revenue bill is actually presented in Parliament. So what the Financial and Fiscal Commission does, which is the equivalent of CRA, is that it is required to provide recommendation in a similar manner to what the CRA is required to do annually on the division of revenue. And the division of revenue, the DoR, is required to be enacted after all the spheres have been consulted, and specifically after the recommendations of the FFC have been taken into consideration. Now, in terms of the criteria for the division of revenue, the Kenyan Constitution provides under Article 203 a criteria which we copied very meticulously from Article 214 to, or Section 214 to the South African Constitution, and only added one or two provisions. So you realize that there's a lot of similarity in the considerations both countries have to take into account when deciding on the division of revenue. Issues to do with the national interest, the debt at the national level, issues to do with the need to ensure that subnational governments are providing services. So there's that sort of similarity also in terms of what criteria is used. Now, what is unique for the South African case is that whereas the Kenyan legal framework requires that the CRA tables its recommendations 6 months prior to the end of a financial year, or at a later date, which should be less than, at a later date to be agreed between the National Treasury and the CRA, the South African Constitution requires that 10 months before the end of the financial year, the Financial and Fiscal Commission ought to have tabled its recommendations. It has to provide these recommendations to the National Executive, provide these recommendations to the National Assembly, provide these recommendations to the National Council of Provinces, and to the individual provincial legislatures, which are required to discuss these recommendations 10 months before the end of the financial year. So once these recommendations have been provided, then provincial, it forms a basis for example, the voting in the National Council of Provinces is done in such a way that they are representatives of provincial legislatures. Therefore, they have to get a mandate. So if they're going to vote on a Division of Revenue Act, the provincial legislatures ought to have sat beforehand and decided what position they're taking on the Division of Revenue Act, and therefore advise their delegation in the National Council of Provinces on what that province input is on the Division of Revenue Act, and that delegation has to act on that basis. So, and another thing, unlike the Kenyan situation, is that whereas the National Treasury in Kenya provides an annual budget policy statement which sets out the annual division of revenue, we have a multi-year budgeting system in the sense that what the minister presents in Parliament is not just a budget or other allocations or proposed allocations for just that year alone, but he provides allocations for 3 years, for the medium term. So, for example, for this year, they provide estimates for next year, for the next 3 years, in such a way that there's that element under Article 203 or Article 2, Section 214.2 of the Constitutions of Kenya and South Africa, respectively, of predictability, in such a way that subnational governments have to be sure, or to have a level of confidence that this is the amount of revenue that we expect this year, or this is the amount of revenue that we expect the following year. And therefore, what South Africa does is it requires estimates to be provided for 3 years. Only that for that particular year, the voting only happens for that division, or the division for that particular year. The others are merely projections which are attached to the Division of Revenue Act. So after the FFC submits recommendations 10 months before, the minister considers those particular recommendations, and before the minister introduces a Division of Revenue bill in Parliament, he has to consult the FFC. So there is more or less like a double, a back and forth in terms of consultation between the FFC and the minister before the tabling of the Division of Revenue bill. Now, another thing is that when the minister is tabling this Division of Revenue bill in Parliament, what Kenya requires is that any significant deviations, which is what the Supreme Court was also, discussing, is that any significant deviations have to be explained in a memorandum. Now, what the South African legal framework requires is that not just a significant deviation, but any single recommendations that the FFC has provided regarding the Division of Revenue, the minister has to explain how they took that into account. So in such a way that the minister has to take into account every single recommendation and explain why they took a decision against or for whatever the FFC recommended. So that sort of ensures that there is a sense of accountability in that the minister cannot just ignore some recommendations. And you realize even the Supreme Court did not really quite explain what a significant deviation is. He says it's a thing to be decided on a case-to-case basis, but in the South African context, every single recommendation has to be explained in the memorandum. Now, in terms of the voting process in Parliament, that is the National Assembly and the National Council of Provinces, has a situation like the Kenyan one arisen. None that I can remember of, or none that researchers actually can reveal. So there's not been any sort of an impasse where, the Constitutional Court has to be approached to give an advisory opinion. So, and this is because, unlike the Kenyan situation where in case a bill is defeated after mediation or after emerging from mediation committee, then that bill has to be reintroduced again. Now, what happens in South Africa is that if a bill is introduced, for example, the DoR, the Division of Revenue bill is introduced in the National Assembly, then forwarded to the Senate. If the Senate rejects the bill, in the South African case, that bill is not, the mediation procedure comes in, but then after the mediation procedure, if either house rejects the bill, now the National Assembly in South Africa has a veto power, in the sense that once that bill goes back to the National Assembly, it can lapse the way the Kenyan situation provides, but the National Assembly has the power to actually pass it anew, but with a 2/3 vote. So 2/3 of the members of the National Assembly, if they pass that particular bill, it now overrides the requirement for any consent of the National Council of Provinces, and the president can actually assent to it. So you realize that veto power sort of resolves the issue of an impasse. And another thing that also fosters good relationships between the two houses is that the Constitution requires that all bills, not just bills concerning county governments, as is the case in Kenya, all bills have to be referred to the National Council of Provinces. So in a sense that it recognizes that the National Council of Provinces or the Senate in this situation has something to say with respect to each specific bill. So the difference only comes in the sense that all other bills that do not concern county governments, or all other bills that do not concern provinces in the South African case, if, for example, the National Council of Provinces gives comments, the National Assembly reserves the prerogative of either amending or not amending, or passing it without actually taking into consideration the recommendations of the National Council of Provinces. Only the DoR is where now there is a mediation process. So in terms of whether if a budget has not been approved before the end of a financial year, the Financial Management Act allows for withdrawals to be done against the consolidated fund until a budget is passed. So despite that way of resolving the impasse, the Public Finance Management Act recognizes that there is situations where a budget may not be approved within the required timelines, and therefore allows for withdrawals to be made. I think I've been mentioning variously some of these issues that are mainly major differences in the way South Africa handles its revenue division process and the way Kenya handles its revenue division process. In terms of lessons, really, it's a question of actually looking at what is the South African process doing differently, and whether it is something that is desirable for us to be able to adopt, or whether there are unique circumstances that allow it to work in South Africa and that cannot allow it to work in Kenya. So I was just finishing off on the question of the disbursement of funds. Just similar to the situation in Kenya, there's a requirement that funds be disbursed promptly without any deductions unless they've been stopped. But then now what the South African laws do, especially, under the Division of Revenue Act annually, is that for provinces, the similar situation with Kenya, there is a requirement that the National Treasury draws up a payment schedule, which is then supposed to be followed. So this payment schedule is supposed to be done in consultation with provinces, and then now it's supposed to be approved 14 days after the Division of Revenue Act has come into effect. So that ensures that 14 days, 2 weeks after the Division of Revenue Act comes into force, there's a disbursement session to allow for the funds to be disbursed as quickly as possible to the provinces. Now with municipalities, what happens is the Division of Revenue Bill provides for these funds to be disbursed on a quarterly basis, and it provides very specific dates. For example, last year's Division of Revenue Bill, Act, stated that funds to municipalities have to be disbursed on three disbursements. The first one is going to be on 8th July 2019, the second one on 2nd December 2019, and the last one on 16th March of 2020. So you realize there's very, very specific dates for which these funds ought to be disbursed, and on a quarterly basis. And then now the National Treasury is just allowed to decide how much is supposed to be disbursed to the various municipalities on those stipulated dates. So you realize that this is something that the Supreme Court did not really find quite interesting. They say that it's something they cannot be able to make a determination on. So from what I've just said, again, in terms of lessons for the Kenyan system of division of revenue, as I said again, one of the things also which has impacted, as I mentioned this at the start, or minimized any sort of controversy or a standoff between the National Council of Provinces and the National Assembly, one is there's a very rigorous process of intergovernmental consultations and intergovernmental process that take place prior to the enactment, or rather the presentation of the Division of Revenue Bill. Up to the extent that by the time the Division of Revenue Bill is tabled in either houses, almost everybody is actually on board. So you realize that the Budget Council is made up of the minister, who is the Minister of Finance, and finance ministers of all provinces. So you realize that deliberations take place at that particular level, that all provinces, all national executive, provincial executive are involved in terms of the consultations before the Division of Revenue Bill. And when it comes to the National Council of Provinces, the premiers or the governors are actually involved, in the sense that these are decisions that are actually made at the provincial legislatures. And when the executives, or the member in charge of finance of the various provinces take part in the consultations, they get their mandates from the premier, in such a way that by the time it gets to the National Council of Provinces, where the premier leads the delegations from the provinces, the premier has been part of the whole process until the point where this bill comes into the National Council of Provinces. The other thing that makes also the National Council of Provinces not as antagonistic to the National Assembly as the Senate is to the National Assembly in Kenya is also the proportional representation system that I mentioned, and the dominant role played by the ANC. So you realize that in South Africa, there is a very significant level of loyalty, party loyalty. What the national executive says goes. It doesn't matter whether you're a national council of provinces, it doesn't matter whether you're a provincial legislature. The ANC occupies like more seats in the National Council of Provinces, more seats in the National Assembly, more seats even in municipal councils in such a way that there's a monopoly of the ANC. So there's very little resistance. The thing that I mentioned is that the bill is the recommendation of the CRA or the FFC in South Africa is tabled way early, 10 months before the new financial year. So there's sufficient time for deliberations, for intergovernmental consultations, in such a way that by the time the Division of Revenue Bill is tabled, all these consultations and the FFC has been involved, and there's a bit of consensus that has actually been developed. So also, as I mentioned, the specific dates that are provided under payment schedule under the Division of Revenue Act. Whether this is something that Kenya needs to do, I'm not sure about that, because you realize even though there are specific payment schedules and dates that are provided in the Division of Revenue Act in South Africa, the National Treasury is given the mandate to actually make amendments to these payment schedules on the basis of cash flow. So what is really clear in the South African situation is that, one, the issue of delays has not been an issue. So you realize that when you look at the literature or, any research that has been done on municipal governments or question of revenue in South Africa or the operation of the National Council of Provinces, the issue of delays has not been a major issue that has been canvassed, which means that the equitable share is sent out per the schedule, and any shortfalls as provided in all annual Division of Revenue Acts is borne by the national government.
With regards to the time and the schedule, we will move on to the Q&A. And there are questions that have come through. We have a question from Mr. Peter Wanyama, and this is with regards to the politics that inform the Division of Revenue process. And he brings out the issue of the attitude of the judiciary towards the entire dispute resolution of the Division of Revenue process. Wakili Kamotho, I would ask you to take that on. And then we have a question on the prevailing political power relations, where the judiciary appears subdued. What is their impact in resolving the dispute resolution? And I think, Wakili Kegoro, you can take on that issue to just bring out the issues of the dichotomy of the power relationship on this issue and how they're playing out. How can politics be removed from this process? To Mr. Ochiel, can you please elaborate on the binding nature of the Supreme Court advisory opinion pursuant to the provision of Article 163(6)? A question to Mr. Gishana. What is the role of the National Treasury in budget making process in South Africa, and who tables the bill? To Mr. Gishana, there's also a question on the issue of division of revenue in comparison to South Africa. There's a question to Wakili Kamotho. What can we do as a country when state actors flagrantly disregard court advisories, especially on revenue division? What is your recourse when the system fails? What is the relationship between the delayed disbursement to counties and the pending bills? Wakili Kamotho, I think that is a question you can take on.
Let me start with the easier one, which is the delayed disbursements and its relationship with pending bills. This is the reality. The process has produced an outcome where county governments do not get money for development in time. Don't forget that county governors and county governments are also political organs, which must be seen to be delivering development, to use Kenyan language. So when they don't have money, what they do is they actually borrow from contractors, borrow in quotes, because they offer contracts, they do not have the money to pay, but they have to be seen to be building markets and parking spaces and water and those things. They have to be seen to be doing that. So what they do is they then contract, and because most people are desperate, they then have to contract with governments. But the money does not come, so they don't pay, and that then becomes, by the end of the financial year, these become spending bills. This process is especially difficult during the transition from one government to another. Because if the previous government is not re-elected, it means that you have a new administration whose first agenda is to make sure that their opponents' projects, because they also have new projects. And so, whatever is outstanding, which is a carryover from the old administration, is not settled, and also there are questions about whether, the validity of some of these bills. So there's a very direct correlation. And so I think the thing is that the effect that this has had on the economy is that it has actually led to impoverization of people in the rural areas. Because remember that the people who do contracts for county governments are small scale, operators. They're small guys with one lorry who deliver SAD, a guy who delivers, and so a lot of those people have actually gone into very serious debt. And that has a huge impact on the success of that component of devolution. And I think it's not therefore just a problem for counties, but a problem for our entire economy. On the question of politics, let me say this. The truth of the matter is that ultimately revenue division is a political process. It's what the Constitution tries to create is an institutional framework so that the political actors can, aided by the technical expertise, reach decisions that they then can own politically. The problem is that when you have a dysfunctional political system, then that infects the process of revenue division. When you have a culture that is actually anti-devolution, because I think we have a very strong anti-devolution sentiment, particularly within the national government and the national executive, when you have an anti-decentralization, then you will see that will affect the way in which we abide by the law. And how we interpret the law, how we misuse what are normal powers. But when you have a commitment, like in South Africa, to devolution as a concept or development, where the ANC owns the concept of decentralization and devolution as part of its core spirit, then those sorts of problems tend to disappear. What can be done? My view is that one of the things we need to have is for Kenyans to understand, because ultimately there's only so much that the courts can do. Even when courts give orders than this and those orders are violated, what are you going to do? Are you going to put the PS for contempt? Even if he's put for contempt, he needs then to be arrested by the same government. So in a sense, what you want to do is ensure that the conversation moves away from conversations between lawyers and moves away from a conversation just about county governors, because what happens is when COG raises this issue, people think, they just want more money, so that, the conversation needs to move from there. And we need to be very, very careful about the narrative that says, all this money that is going to county governments is being lost, is being stolen. Because the truth of the matter, where there is corruption in the county governments, and nobody doubts that, if you were to do a comparative shilling for shilling comparative loss of public funds, you'd be amazed, because what gets lost, and it's unfortunate that it gets lost in the county governments relative to what happens in the national government, is minuscule. And that narrative needs to be owned, so that we say, look, at the end of the day, let us empower county governments, because county governments are not about governors, they're about the citizens. And so the culture of violation, part of that is an uproar by the people when they realize that these violations have a direct impact on their own welfare. And so it's actually to democratize the conversation so that people understand what these conversations are about and what impact it has, like what you talked about pending bills. So I think in terms of the law can probably, even the Supreme Court decision can take us so far. But if there's no commitment to abiding with the law, there's a sense in which we need to take that conversation to the people. Right now, there's a provision that says monies must be paid to county governments by a particular time. They are not paid. So the problem is not just that the law has defects, but there's a spirit of violation. And that spirit of violation needs to be something the country's citizens need to own. And then we can then decide what to do at a political level to ensure that governments do not violate the law in our face, especially when it prejudices us.
Listening to you, we get the sense that it is about our attitude and the culture. If we don't change those, we are here for a long haul, for a long while to come. What we need in this country is champions, people who believe in devolution, and devolution being about the people and not about personalities. I mean, it is a game changer that we need to make sure we democratize and allow it to really deliver what it was meant to do, service to mwananchi. So moving forward, I think we need to do away with the violation spirit, the spirit intended to violate and plow back on the gains of devolution as envisaged by the Constitution.
I think there are a couple of questions that were directed to me, and one of them from Duncan was whether the recommendations of the Fiscal and Financial Commission in South Africa are binding on the legislature. No, they're not. What the legislature and parliament is only required to do is demonstrate that they have actually taken those recommendations into account. And what usually happens is that when the minister presents the budget and the Division of Revenue Act to Parliament, there's a budget review that is usually attached to the budget and also the memorandum. One of the things which you will realize when you look at the budget review is that each and every recommendation of the FFC. Now, unlike Kenya, where any member of the National Assembly may present a bill in the National Assembly, there are gradations in South Africa as to who can present what bill. And with respect to the DoR, or the Division of Revenue Bill, only the minister in charge of finance is allowed to present the Division of Revenue Bill. And what the national executive does in that case then is the one that originates these bills, is the one that undertakes these consultative processes before the tabling of this bill, is the one that considers the recommendations of the Financial and Fiscal Commission before it actually tables this particular bill. And you realize that it plays a role in that particular manner. So, and then the other question was, not a question, but a recommendation. And then generally in terms of what Kamodo mentioned about South Africa, the ANC being pro-decentralization is really not the case. And I think when I was actually looking at the questions which I was supposed to respond to, is the part where it was talking about what lessons can Kenya learn from South Africa. I really don't think the lessons we can actually learn from any particular country, because you realize that in terms of what informs the practice in that particular country is a conglomeration of so many factors. And therefore what we ought to actually ask ourselves is, what is this particular country doing differently? And why are they doing it differently? And if that reasoning or rationale is relatable to our circumstances in Kenya, then we can be able to ask ourselves whether it's something we can be able to consider. Now, the question of the ANC was against federalism, against decentralization, even prior to independence. The negotiations that led to the implementation, or rather to the enactment of the interim constitution in South Africa, the ANC was adopted a very centralist stance. They didn't want provinces because they were afraid that these provinces are going to be, create sort of, divisions and entrench the system of apartheid that used to be there. And it only took negotiations for the ANC to just concede and allow these provinces to go on. But what the ANC did after having been forced to concede is what has resulted into what South Africa's system of multi-level government is referred to as an hourglass system of government, in the sense that there is a central government, a strong central government at the top, a provincial government which is very weak at the center, and a strong local government. So the opposition of the ANC to provinces led it to take away the powers of provinces and strengthen local governments so that at least provinces have very weak powers. So you realize that there's not so much a support in terms of the ANC. The ANC is very centralist, even in terms of its decision-making, even in terms of its own party structure. So what advantage South Africa has over Kenya is that it has a very strong tradition of constitutionalism and respect for the rule of law. And court decisions are actually taken very seriously, especially decisions from the Constitutional Court. So you realize that's not something you can be able to replicate. Discipline and respect for the rule of law and constitutionalism is not something you can be able to replicate in terms of lessons. It's something which can be built over time in terms of institutions. Therefore, I think as much as we want to pick lessons, let's also be very keen on what the specific circumstances in this particular country is. Thank you.
Thank you, Mr. Gishana. I'll still go back to what Wakili Professor said. It's about the culture, the political attitude towards the Constitution, the rule of law, and the spirit of the Constitution. So over to you, Professor Guy.
How can politics be removed from the process? This is the heart of the problem, really. One of the observations in the chat was suggesting, well, all this talk about law and the Constitution and so on is all sort of too technical and irrelevant because what really matters is the politics. But a problem that we constantly have. Politics is supposed to be in our interests. And there is supposed to be this combination of expertise and politics. Politics not just for the interests of the individuals who are concerned, but politics for the benefit of the people of Kenya. It's interesting to note that in the sort of models in other countries, under the Indian Constitution, they have a thing called the Finance Commission. Rather similar, appointed politically, but and they make recommendations, but so at least from the early days, I'm not sure whether it's still true, but I think so, that they had a tradition of appointing such skilled people that the recommendations of the Finance Commission have always been accepted. If we had our Commission on Revenue Allocation was to make the final decision, would we trust them? We'll look at all the other commissions. How many of them do we trust? Look at the IEBC, for example. Look at the EAC, Anti-Corruption Commission. We don't seem able to produce institutions, whether they are political or expert, that we can really trust. And so, in a sense, that's why the Constitution tries to set up this tension between the politics and the expertise. And I'm not sure the solution is to be all political or all apolitical. Okay. And the problem is that, in South Africa, as Henry Paul has been saying, it's not that they take this out of politics, it's just that essentially they have something not far from a one-party state. And so every time you look at the way the South African Constitution is functioning, you have to factor that in. If their politics were so divisive as our politics are, do you think they would be able to deal with these issues as smoothly, relatively smoothly, as they are able to now? Let me say, sometimes it seems that some of our politicians are rather hoping we will have a return to a one-party state, effectively, which would be taking the politics out of these decisions. I don't think it's the solution. Somehow we have to develop institutions that we trust for their political judgment and for their expertise.
Over to you, Dudley. You had one question which kindly answer in 1 minute, so we are able to wind up within time.
In 2011, that was one of the questions the Supreme Court had to first deal with in explaining the binding effect of its advisory opinions. And that is the matter of interim independent electoral commission. And the Supreme Court looked at advisory jurisdictions around the world and returned the verdict that its advisory decisions, opinions are binding. First, because it is a decision of the court. Parties submit on facts, submit on the law, and then the court makes a decision. So it is a decision of the court and it is binding. Secondly, the Supreme Court held that because of the very special nature of that jurisdiction, touching on the most pressing of constitutional questions, it is not a jurisdiction that should be moved for the sake of it. Someone should be able to seek an advisory opinion, hoping that the Supreme Court would endorse its decision. So it's binding not just on the seeker, but also on all other state organs.
Okay. Thank you, Mr. Chair. Over to you, Mr. Kegoro.
So in the advisory opinion, then writes this separate opinion, separate concurring opinion that is full of frustration at every point. It is, you can see the frustration that coming through the way he expresses himself, and then he concludes with the following words: "I hope this is the last time this or any other court is called upon to pronounce itself on the issue that in our current constitutional architecture, the division of revenue between the two levels of government is one of the central issues concerning county government, demanding the full participation of the Senate as required by Article 96(2). So that is basically that language of he hopes this is the last time, because we are tired of deciding this and having to decide it again and again and again. So that displays one the attitude on one side of the court.
Okay. This
is the conclusion that Njokindungu had in her dissenting opinion. She says, I'm of the opinion that the majority decision is woefully misinformed and has brought little or no resolution to the legislative conundrum that has been presented before us by the parties." Okay. So the judges are lecturing each other. The two sides of the decision are lecturing each other, and they're very unhappy with each other about the decisions that they're making. So Njoki is lecturing the majority. The majority is lecturing the political establishment. This is very much a reenactment of the 2017 election petition situation where Njoki is lecturing the majority judges and lecturing the public rather than trying to convince the public about that he should go with her. This leads to the conclusion that I made already, that this has become a highly ideological dispute. It doesn't matter what, there is no more law and there is no more fact that you can bring to the matter. Only attached to the positions they've taken are about how this issue should be resolved, and therefore the court can't now move us forward. And the courts represent. They've been given the thankless responsibility of resolving a dispute, which they can't, because the dispute is part of the heart of the politics of the country. And as Kamodo said, the only way then to try and resolve this issue is to take it back to the political plane where issues of fast politics are resolved.
Thank you so much. Now, that has been a very interactive session. And just to bring it to conclusion in a few minutes, I would just want to ask the panel to give us their final words on what they think will be, we will be talking about division of revenue come next allocation. What is the future trend likely to be?
Supreme Court helped move the discussion a little forward. But I think we have to see this in the context of a broader question about the acceptability and the commitment to a devolved system. For as long as there's suspicion on decentralization and devolution, the power dynamics are going to fight removing power from the center. That's a reality. And so for me, I think the technical issues, we have moved a few steps. I do not believe that we have resolved the issue fully. I think the Supreme Court helped, but it didn't resolve. But I think ultimately this is an issue that has to go and be owned by Kenyans as a conversation that moved away from COG and moves up from the actors to a broader conversation about that what is going to sustain this country as a working country is strong devolved governments. If we don't do that, the crisis we will have is much bigger than we anticipated even in 2007. People need to own that reality so that we resolve these problems together, as opposed to winners and losers, which is sometimes what the court gives, which is a good thing, but it doesn't resolve the issue fully.
That's right. I don't see this ending. I mean, maybe it'll take a sort of different form, but it's a recurrent issue. Let me also add one thing that was, I think when George was speaking, George Gigoro, about the interest that the National Assembly members have in the national, the allocation to the national government, just made me more convinced about what a bad idea the NGCDF is, if this actually can influence the way in which they go about deciding as important as the distribution of national revenue.
What I think needs to be done is more effort made to shine light on the role of NGCDF in how we've come into where we've come. You've got to dislodge that incentive from the National Assembly. It's an important part of why this ends up playing out the way it does. In the last budget, I was checking. I mean, Parliament now controls 89 billion from the last budget, 46 for the NGCDF, and 43 as its institutional budget. The judiciary 18.8 billion. So that gives you a sense of how important money, personal interest, the personal interests of a very small group of actors has become in deciding national issues. And then instrumentalizing the presidency, instrumentalizing the treasury in ensuring that very narrow interest is reflected in how decision making at the budget decision making is handled. So that's an important part. The second important part is what has been said by everybody else, that because there's no commitment now to devolution, as seen how money is handled, and new champions that link budget decisions and whether or not devolution can work are needed, and the need to take that question back to the public and away from the courts and from the corridors where it has been discussed.
We started off with a decentralized government at independence, and the political elites soon killed that system and gave Majimbo a bad name. It made it sound as if having Majimbo, where people can decide on their governance, was a recipe for disaster. And so we spent about 50 years fighting to get power decentralized again until the 2007 post-election violence, the current constitution, where we began, where the political elite again are trying to re-centralize power, implementing devolution fully. And we should counter that as citizens by focusing our interest on questions of devolution. Let us look at, for example, this year's division of revenue bill and ask the questions we need to ask as citizens. Because as Maraga warns, unless we make devolution work, then we are heading back to the situation of 2007. Thank you.
So the question as to whether we are going to find ourselves here again. Now I'm speaking as a Kenyan, more or less, lesser than South African in this particular case. Are we going to find ourselves in a situation where there is a stalemate or an impasse between the National Assembly and definitely? Why? Because the issue has not been resolved. Where a bill that emanates from the mediation committee is rejected, it's defeated. There's no way out. There's no veto, for example, like the South African case where the National Assembly may pass that bill again, but with a 2/3 majority. We don't have that. Do we want to include that to enable the National Assembly to veto the position taken by the Senate? I'm not sure whether we want to go through that route. Now, are we going to see a situation where the appropriation bill is passed again before the enactment of the DoR? Probably not, unless the executive, with the support of the National Assembly, decides again to continue with its, crusade of disobeying court orders. Now, are we going to find ourselves in a situation where we want timelines to be provided, I don't think we'll be able to get to that point. So okay. I think for me, what we just need to maybe focus on is whether there is more that is done to ensure that court orders are actually, especially even the advisory opinion, is actually respected.
Okay.
So I think more should be done to actually build the institutions and just ensure that the constitutionalism is upheld.
Thank you to all the participants. Thank you to our able panelists. I think we have had such a good session, very interactive, very informative. I wish to thank all of you and wish you a good day moving forward. And thank you so much.